Okay. Now, Calhoun was advancing, and Hayne were advancing this idea of the states acting as a check, as a way of protecting minority rights against majority rule. But actually, one of the clearest examples we have of the majority posing a threat to the minority comes not in the case of South Carolina and the tariff, but really in the case of Native Americans versus white Americans. And what had happened with the expansion that I talked about earlier was Native people who previously had been, had entered into treaty arrangements with the United States government now are being pushed out. Very complicated story, sad story, which we won't dwell on too much. But okay, so in 1820. There still were about 125,000 Native people east of the Mississippi River. And in the southeastern part of the United States, there were 5 nations called the civilized nations because they all had settled villages, settled agriculture, and they've been around for a long time. In many cases, in good trading relationships with the whites. We don't need to go through the whole colonial period to talk about the particulars of these different groups. The Cherokees, in what today would be North Carolina, South Carolina, Tennessee, Iroquoian-speaking group, the Creeks, who lived in what is today, western Georgia, eastern Alabama, going down to the Gulf of Mexico. Then the Seminoles were a branch of the Creeks, along with other folks who had gone south into Florida. The Choctaws in central Mississippi, and the Chickasaws in northern Mississippi, all living in fairly substantial villages with fairly sophisticated political organizations. And in the War of 1812, the Creeks had sided with the British, perhaps a mistake, unless we talk about the way the war looked, so maybe it wasn't. The Cherokees had sided with the United States, as had the Choctaws. Jackson and the Cherokees had actually defeated the Creeks at the Battle of Horseshoe Bend. The Cherokees had split. It's actually, the Cherokees have a very interesting history in that there's a split in the Cherokees going back to the 1790s, first decade of the 19th century, between assimilationists, those who say, okay, there are lots of things the whites are doing that we can do too. Have plantations with slave labor, have a written language, have a written newspaper, adopt a constitution. The more assimilationists, the more prosperous among them will send their sons to New England boarding schools where they will really become acculturated. So, for example, one of the leaders of the assimilationists among the Cherokee is a fellow named Elias Boudinot. It's a name he actually takes. Those of you who have been paying attention know that in the 1790s, very important Federalist Speaker of the House was Elias Boudinot, a congressman from New Jersey. So this particular Cherokee youth is educated in New England and takes the name of a prominent Federalist. Causes some confusion for those of you who think, well, how does Federalist wind up among the Cherokees, or there was a Cherokee Speaker of the House? There wasn't. On the other side, there are more traditional Cherokees who are hostile to white encroachment and say, why do we want to adopt white values? Probably the most prominent of these is a guy whose name is The Ridge. It's short for a Cherokee name, which it's he who walks on top of the ridge. And his son becomes John Ridge, very interesting family. Okay. So the Cherokees have this split. The Cherokees will adopt a constitution in 1827, declaring themselves to be the Cherokee Nation. And their constitution is modeled on the U.S. Constitution. You probably also know that in the 1790s, early 1800s, a Cherokee named Sequoyah develops a written language for the Cherokee language, transliterating it into letters, so that the Cherokee language is written. They start publishing a newspaper, the Cherokee Phoenix. Again, Phoenix, this bird that rises from the ashes. And they adopt a constitution in 1827, declaring themselves independent. They have a treaty with the United States. All of these Indian nations have treaties with the United States, and which set out the boundaries of their territory. So this group of Cherokees declares themselves to be, the Cherokee Nation, which the United States, in fact, already recognized the Cherokee Nation. That's why there were treaties. Okay, so this is one part of the story. Now, the Cherokees, as I said, also live within states, in this case, Tennessee, South Carolina, North Carolina, and Georgia. And the Creeks also live many Creeks in Georgia. And the Creeks have treaties with the United States. In 1826, the state of Georgia decided, it really would be beneficial to us if we could sell the land that the Creeks are sitting on and develop that as part of Georgia. And so Georgia sends surveyors into Creek territory to start measuring out the Creek land. The Adams administration had negotiated treaties with the Creeks. Georgia says, that's really too bad because they actually live in Georgia. So what's in Georgia belongs to Georgia. Who are these folks and why is the United States making treaties with them? And remember, this is 1826. 14 years earlier, the Creeks had been at war against the United States. So they don't have a whole lot of allies in white society. So when the Creeks find that their territory is being encroached on by the Georgians, President Adams says, you can't do this, you can't encroach on Creek territory, and Georgia says, who are you to tell us what to do? We're a sovereign state. And members of Congress also aren't that wild about John Quincy Adams. So, Adams, as president, has no real power to protect the Creeks. Now, that's the Creek story. No real friends in high places. Okay, the Cherokees do have friends in high places. The modernizers among the Cherokees have said, hey, we're just like white people. We have plantations. We have slaves. We're growing corn. We send cotton. We're sending our sons up to New England to boarding schools. And that we have a constitution, just like the U.S. Constitution. We also have newspapers. Okay, so Georgia, though, doesn't see that, Cherokee country in Georgia. Why shouldn't we sell that the same as we're selling the Creek country? Okay. Now, as I said, President Adams tries to protect the Creeks, finds he cannot, and then, of course, things change in 1828 with the election of Andrew Jackson. And in his first annual message, President Jackson says, Indians cannot create new states within the old states. Some New Englanders say, oh yes, these Cherokees down in Georgia can start their own state. But imagine if the Passamaquoddies in Maine decided they were going to set up their own state. Or the Iroquois in New York said, we're going to set up our own state. These folks would sing a different tune. And Jackson spells out his policy on Indians, which basically is that they all should be moved west of the Mississippi River. And so in 1830, Congress passes a removal act, which says the federal government will make treaties with these native people by which these native people will cede their territories east of the Mississippi River and be moved west of the Mississippi River to some new territory. The alternative, Jackson believes and Congress believes, is that the Indians will become extinct unless they're moved out of the way. Let's see. Surrounded by whites with their arts of civilization, Jackson says, which by destroying the resources of the savage doom him to weakness and decay. The fate of the Mohegan, the Narragansett, and the Delaware is fast overtaking the Choctaw, the Cherokee, and the Creek. Okay, so unless we get these people out of Georgia, they're all going to die because the whites will take all their land, kill all the animals, and same thing that happened to the Mohegans, the Narragansetts, and the Delawares will happen to these folks. So Congress in 1830 passes the Removal Act to remove the native people. And in his second annual message, Jackson says, doubtless it will be painful to leave the graves of their fathers, but what do they more than our ancestors did, or than our own children are doing, to better their condition in an unknown land? Our forefathers left all that was dear in earthly objects, and our children, by the thousands, yearly leave the land of their birth to seek new homes in distant regions. Does humanity weep at these painful separations? Far from it. Rather, it's a source of joy that our country affords scope where our young population may range unconstrained in body or mind. Also, he points out, nobody is giving our kids money to move out. Nobody paid our forefathers to move, but hey, we're going to bear all the expenses of moving these people west of the Mississippi. So stop complaining. So the president makes it clear he is committed to removing the Indians from east of the Mississippi, and Congress passes the Removal Act in 1830. And even, incidentally, a very complicated story, even people who considered themselves to be friends of the Indians, and in fact in the 1880s this group forms called Friends of the Indians, and with friends like these, the Indians didn't really need enemies, think, yeah, the best thing that can happen is for them to move away from the white people. So Georgia, 11 days after Jackson's first message, this is in December of 1829, sets up county boundaries in what the Cherokee Nation claimed was their nation. Georgia says actually these are Georgia counties. They send in surveyors and they extend state law over the Indian territory, and they pass laws binding on anyone who lives here is subject to Georgia's state laws. And here is what happens then. A Cherokee named Corntassel kills another Cherokee, and under the laws of the Cherokee Nation, he is subject to the law of the Cherokee Nation. And the Indians had particular laws too. Most societies have laws. Actually, murder is a pretty universally outlawed thing. And in the case of the Cherokee, and laws evolve for a particular reason. One thing you want to do is make sure that one crime doesn't lead to lots of other crimes. So what typically would happen before the institution of laws is, let's suppose Mike kills me. The next thing that's going to happen is if I have any friends or relatives, they're going to go try to kill him or kill a member of his family, and then they're going to have to retaliate. So what you're going to have are long blood feuds, carnage, all kinds of bad things. So societies pass laws to prevent this. In our particular society, if he kills me, who punishes him in the United States or in the Commonwealth of Massachusetts? My family doesn't go after him. In fact, they would be breaking the law if they did. Instead, if he's prosecuted, it's the people of Massachusetts. All of you are prosecuting him because you've agreed. It's not, oh boy, it's a bad thing because I'm such a nice guy. It's because he shouldn't kill anybody. It doesn't matter if it's me or if it's someone else, okay? That's the way the law works here. Now, the way the law worked among the Cherokee is one Cherokee kills another. He has to make some restitution to the family. Okay. Also, he can be banished. No one is allowed to speak to him unless the family agrees at whatever restitution he is given. So it's a very complicated thing. They agree, okay, Mike presents blankets, a horse, other things to make up for this. They agree they're not going to kill him. Meanwhile, he can also be banished, not allowed to eat with anyone, talk to anyone. Okay. Now, that's the way the law worked in the Cherokee Nation. It's not the way the law worked in the state of Georgia. Corntassel kills another Cherokee, and he does make the restitution. Meanwhile, the state of Georgia arrests him and puts him on trial, finds him guilty, and sentences him to death. So you have two conflicting systems of justice here. And anyone know what happened? What should happen? I mean, you may think, boy, it's a bad thing. He kills someone, all he has to do is, provide some blankets and things, and everyone says, okay, it's okay. I don't think they ever really say it's okay. Even if Massachusetts punishes him for killing me, I don't think anyone would say, well, it's okay now, he's in prison. So we find ways of dealing with this without having massive carnage. Okay. Now, what happens in this case, Corntassel is sentenced to death. The Cherokee Nation appeals his conviction, arguing that the state of Georgia doesn't have jurisdiction over Corntassel because Corntassel is actually a citizen of the Cherokee Nation and not of the state of Georgia. And the Georgia courts say that's nonsense. There is no such thing as the Cherokee Nation. You're living in Georgia. You're subject to Georgia laws. And in the state of Georgia, the judge in Georgia says the Supreme Court of the United States is asked to hear the case. Well, first, I should say, the Supreme Court has trouble with the case. The judge, this is what happens in Georgia. The Georgia knows that this case is being appealed to the U.S. Supreme Court, and Georgia says the Supreme Court doesn't have any jurisdiction over this. Because at this time, the Supreme Court did not hear appeals of murder convictions of any kind. Simply, this is a state matter. There is no federal law about killing people, so why would the Supreme Court have any interest in this? They don't. And Georgia, when it hears that the Supreme Court is going to hear the case, essentially says, so what? The judge in the Georgia case says, without intending the least disrespect to the Supreme Court, to whose constitutional authority this and all other state courts will most cheerfully submit, this question can never go from a court where I preside until the people of the states yield it. People of Georgia have never said, yes, you can appeal these things up to the Supreme Court. So the Supreme Court of the United States agrees it will hear the Cherokee Nation's case, and while they are agreeing they will hear this case, the state of Georgia executes Corntassel. Okay. And then what happens is the modernizers sue Georgia. That is, the Cherokee Nation sues Georgia for having killed Corntassel, and William Wirt, former Attorney General of the United States, argues the case for the Cherokee Nation. But Wirt is arguing that the state of Georgia doesn't have jurisdiction in the Cherokee Nation, thinks that the best thing the Indians can do actually is get out of Georgia. Okay, very complicated case here, comes before the Supreme Court in 1831, and Wirt is asked, okay, what happens if we find that you are right, the state of Georgia doesn't have jurisdiction in the Cherokee Nation? Which Wirt is saying it does not. What happens then? And the president, as you are aware, has to enforce the law. Jackson's made it clear, doesn't think that the Indians should be in Georgia, thinks they should get out. In fact, he supports removing them forthwith. And Wirt says if we have a government at all, there is no difficulty in enforcing a decision. In pronouncing your decree, you have declared the law, and the president is bound to uphold it. And if he doesn't do that, the Constitution's provided a remedy. That is, the Congress can impeach him. So the likelihood of Congress impeaching President Jackson for failing to enforce a decree of the Supreme Court, I think, is somewhat remote. And Jackson, meanwhile, says that Indians either are foreign nations or they're subject to state laws. And to maintain a contrary doctrine and to require the executive to enforce it would place in his hands a power to make war upon the rights of the states and the liberties of the country. So, he's made it clear he's not going to enforce this. Georgia, so the Supreme Court is going to hear this appeal of the case of Cherokee Nation versus Georgia. Georgia isn't going to send anyone to argue it. Wirt's arguing the case for the Cherokee Nation. No one is arguing for the state of Georgia because Georgia maintains the Supreme Court does not have any jurisdiction in this case. And meanwhile, the federal government Congress passes the Indian Removal Act, and the Indians begin to be removed. Now, in this case of Cherokee Nation versus Georgia, the majority says, speaking through Chief Justice Marshall, says the Supreme Court really can't do anything about this. They do say that the Indians are in a special relationship with the United States. They're not foreign states, foreign sovereign powers, nor are they subject to state law. Rather, they are domestic dependent nations. They are in the same relationship to the government of the United States that underage wards are to a legal guardian. And as such, the court says they can't sue in federal court. Okay, so the court acknowledges they have this special status, but they can't. The court says we can't hear the case because they don't have any standing to sue. Two judges, Joseph Story and Benjamin Thompson, dissent, saying yes, we do have the power. Actually, they do have standing to sue. And Chief Justice Marshall, although the majority disagrees with that premise, encourages these two justices to publish their dissent. But anyway, you see here a line being drawn, a pretty clear line being drawn, with white society wanting to remove the Cherokee and others. The Cherokee modernizers want to stay where they are. The traditionalists say, no, we have nothing to gain by staying here. We should make a treaty getting out of Georgia and moving west. There is an eastern band that will stay in the mountains of North Carolina. Anyway, so this is a very complicated issue here. And the upshot of Cherokee Nation versus Georgia is the court saying the Indians have this domestic dependent status. They can't sue in federal court. If we got a case that we could hear, it might be different. And actually, in March of 1831, a case arrives when the state of Georgia sends, the state of Georgia passes a law saying no one can go into these counties we have just carved up out of the Cherokee territory without a state license. And there happened to be a couple of guys, white guys, living in the Cherokee Nation, both from New England, a guy named Samuel Worcester. And incidentally, I always am happy I teach here in Massachusetts because this is probably the only place in the country I don't have to explain to people how you pronounce the name of this case. It's Worcester versus Georgia. People in Massachusetts know this because everywhere else they mispronounce it. Worcester v. Georgia. And Samuel Worcester and Eliza Butler are two white guys living in the Cherokee Nation, and they are what the Georgia government would call troublemakers. One of them, helps print up the newspaper, and they do other things to say, we like the Cherokee. And they have been living there since about 1820, and actually they're living in Georgia without a license in Cherokee territory. They claim we actually have a commission from President Monroe to live here. Monroe had sent us as agents to the Cherokee, so here we are. And federal commission trumps a state license any day of the week. And these two guys are living down in Georgia. They're arrested for living on Cherokee territory without a license and are put in jail. And now, the court had said we can't hear the case of Cherokee Nation because Cherokee Nation doesn't have standing to sue in federal court. One thing these two guys do have, it's ambiguous about their license versus their commission, is they have standing to sue in federal court because they are citizens of a state. In this case, I believe the state of Massachusetts. One's Massachusetts and one's Connecticut. So this means the case of Worcester versus Georgia can legitimately come before the Supreme Court. And the Supreme Court, which had hinted in Cherokee Nation versus Georgia that it really didn't like what Georgia was doing, but it couldn't do anything about it, now can do something about it. And this is what they do. They say Georgia cannot pass laws like this on the Cherokee Nation territory because the Cherokee Nation is not subject to the laws of the state of Georgia. Okay? Georgia law cannot affect the Cherokee Nation. The court recognized the boundaries of the Cherokee Nation, which were determined by treaty by the United States government. In fact, Marshall's opinion is about 26 pages long. The first 17 are in a whole history of Indian-white relations. Okay? And then points out that the Constitution had been set up after 2 centuries of experience of relations between whites and Indians, and it gave the federal government the exclusive power to regulate trade with the Indians, make treaties with the Indians, and so on. So the Indians are considered distinct political communities by the Constitution of the United States. And the court recognized the boundaries of the Cherokee Nation, which, of course, had been determined by treaty with the United States, and it's a unanimous decision, although there are different judges who reason differently. John McLean, who was appointed by President Jackson, said it's really an issue of federal supremacy over state law. Very clear. Georgia might have legitimate grounds to complain that the national government's been slow to extinguish the Indian titles. Georgia had been carping about this since the 1790s, but if the federal government doesn't take action, that does not mean the states can take action. So the court then unanimously says to Georgia, You can't set up laws over the Cherokee Nation. They send the case back to the Georgia courts. This is what happens, incidentally, when the Supreme Court overturns a law or overturns a proceeding in a lower court. They simply send it back to that lower court and say, okay, this is what the law really is. You can retry the case in accordance with this. So in this case, Worcester and Butler had been charged with violating the law of the state of Georgia. The Supreme Court tells the state of Georgia, actually, this is the law. You can't kick them out, so you can try the case again, considering that fact. And what happens here, the court sends the case back to Georgia, tells Georgia to hear the case again, and if they don't, they have to tell the Supreme Court why they didn't. Now, Georgia had not sent anyone to argue this case either, as Georgia doesn't admit that the court has any bearing on this. So Georgia doesn't take any action, and the court realizes it doesn't have any way of forcing Georgia to do so. And there's an apocryphal story about President Jackson being told of the court's decision and saying, according to the legend, Chief Justice Marshall has made his decision, now let him enforce it. That is, Jackson is not going to protect the Cherokees against the state of Georgia, nor is he going to protect Worcester or Butler against the state of Georgia. Incidentally, so what happens then is, well, the Cherokees essentially win the case, but they lose the war. That is, the court can't enforce it. Jackson is reelected rather easily in 1832, and within a week of his election, well, other things happen that are going to change or influence what happens here. Let me see if I can just tell you quickly what happens. Well, actually, Worcester and Butler ask for the governor of Georgia to pardon them and say they won't press the case. And ultimately, Georgia does pardon these guys because then the United States is doing what Georgia wants, which is getting the Indians out of Georgia. So, long, complicated, ugly story here going on with the federal government removing the Indians from Georgia and the Supreme Court siding with the Indians but finding the president is not going to support them in this. So, actually, fairly recently, well, that is within the last 20 years or so, these doctrines of the Supreme Court, this idea of domestic dependent nations has come back, and well, it's a complicated area we don't need to get into tonight. Any questions on this? Worcester v. Georgia, because it's Cherokee Nation versus Georgia. You have this. Well, we'll get to this in a bit. The whole notion, it's being played out against this backdrop of other threats to the Union, political threats to the Union. And before we get to those, let me tell you a bit about this other big issue of 1832, which is the bank. I know you thought we were done with the bank back in, 1791. We had a big controversy about the bank, 1811 controversy about the bank, 1815, 1816, then 1819 with McCulloch versus Maryland. But we're not done with the bank. Anyone happy to hear that? Boy, more about the bank. Okay, this is what happens. The banking system is a fairly complicated thing. I think as we've discovered in recent years, banking is a fairly complicated thing. And when things go wrong, they can go really, really wrong. And you may think, boy, I never want to hear about a bank again, until suddenly you do, and it becomes quite difficult, painful, and people start losing their jobs. Now, the head of the Bank of the United States was a fellow named Nicholas Biddle, who was a Philadelphia banker. The Biddles, big family in Philadelphia, and he was a good banker, which means, essentially, he makes a lot of enemies because one thing a good banker does is restrict credit, not loan out money to people who are bad risks. And you do that enough, people get really sore, particularly if you're head of the Bank of the United States. Okay? And the Bank of the United States has grown a bit. It has branches in Washington, Nashville, New Orleans, other places, and very useful thing as far as stabilizing the economy and so on. I don't need to explain banking to you since I barely understand it myself. Now, 1832, Why are we talking about the bank? Because I know you're thinking, back in 1816, hadn't Congress chartered it for 20 years? So how come in 1832, even if you don't know any math, you can figure out that's only 16 years, and the reason is this. 1832 is an election year. Henry Clay is anticipating running against President Jackson, and he's looking for a good issue to use against Jackson. And one is, Clay would be better for the economy, and the bank is central to Clay's vision of a national system or an American system. And so what he will do is recharter the bank now, so you won't have a period of uncertainty in 1836 about whether the bank will be rechartered. So Clay, who is Speaker of the House, gets Congress to recharter the bank in 1832, 4 years early, so investors in the bank know they don't have to worry that it's going to get its charter revoked in 1836. This is a good idea to do this, that, have the thing rechartered, okay? And this also will show, Clay really, understands the workings of the economy and understands the importance of the bank as this balance wheel at the center of this very complicated economic system. Very smart political move on Clay's part, as he is anticipating running against Jackson, who is centralizing power, doing these other things which are bad. And, the bank is popular among the Philadelphia merchants and capitalists, the New Englanders who like the sound currency and so on. And so this seems like a good thing to do. Clay hadn't anticipated, I think, that Andrew Jackson also knew something about playing political hardball. And on July 4th, Jackson vetoes the rechartering of the Bank of the United States and says that this recharter is an attempt to drive up the value of the bank's stock and to enrich the bank's shareholders at the expense of the public. And do you know who owns a lot of stock in the Bank of the United States? Foreigners. Foreigners. That's what's going to be your next guess. Clay may as well. Clay, actually, Jackson's money is in the Bank of the United States, incidentally. So is Clay's. Okay? And so, the Bank of the United States presents a danger to the purity of elections in America and to the livelihood of American citizens from the self-elected directory whose interests are identified with those of the foreign stockholders. And if this bank gets control, continues to assert its control over the American economy, President Jackson trembles for the independence of the American people. This is on July 4th, mind you, okay? And so, now that's the political argument. Foreigners attempt to enrich shareholders in the bank, and an attempt that the bank would have the power to interfere in elections. Then there's a constitutional argument. It has been maintained by advocates of the bank that its constitutionality and all its features ought to be considered as settled by precedent and by the decision of the Supreme Court. To that conclusion, I cannot assent. Mere precedent is a dangerous source of authority and should not be regarded as deciding questions of constitutional power except where the acquiescence of the people and the states can be considered as settled. Okay? And so, is the bank constitutional? 1791, Congress said yes. 1811, Congress said no. 1815, no. 1816, yes. So that looks like a split decision. As far as what states said, it was 4-1 against, state opinions on the constitutionality of the bank. Now, yes, the Supreme Court said it is constitutional if the opinion of the Supreme Court covered the whole ground of the act. It ought not to control the coordinate authorities of this government. The Congress, the executive, and the court must each for itself be guided by its own opinion of the Constitution. The authority of the Supreme Court must not be permitted to control the Congress or the executive when acting in their legislative capacities, but to have only such influence as the force of their reasoning may deserve. So, who runs the country? The president, who's elected by the majority, or the Supreme Court? Well, if the Supreme Court can convince him, then yes, he would agree with them. But he's not convinced by what the court said in McCulloch versus Maryland. In McCulloch versus Maryland, the court had said a bank may be needful. However, Congress can change its mind about what is needful or not. And as Congress had in 1815, 1811, and said the bank isn't needful. So the court said it is, but Congress can change its mind. And the president also can have a different opinion. And Jackson's opinion is certainly different here. He has clearly read Jefferson's argument against the constitutionality of the bank, and he thinks Jefferson was absolutely right. The bank was unconstitutional in 1791. It is still unconstitutional in 1832. As far as the bank being a necessary evil, there are no necessary evils in government. Its evils exist only in its abuses. If it, that is the government, would confine itself to equal protection, and as heaven does its rains, shower its favors alike on the high and the low, the rich and the poor, it would be an unqualified blessing. So, the president vetoes the rechartering of the Bank of the United States, explaining why, because the bank is unconstitutional, and we tried to tell you that in 1791, and we don't really believe the Supreme Court's the final word on this, so there you go. And just so you know what happens, it's kind of interesting here. Jackson argued that banks are dangerous instruments and can throw things out of whack, do a lot of damage, and then, in fact, Nicholas Biddle set out to prove him right. Biddle, as a way of showing the bank was really important and you couldn't get by without it, restricted credit, and this provokes a financial depression. So bank presidents typically are not as adept politically as presidents are, and most people will blame this panic depression on Biddle and the bank. Jackson had said they're dangerous. Now seems to be proven they're dangerous. So, yeah. It's really a victory for Jackson. Although, and he's then, much to Clay's surprise, Clay thinks it's a disaster to strike down the bank. Jackson's reelected in 1832 quite overwhelmingly and sees himself, this is what the president should do. Speak for the people against a special interest like the bank. And then Jackson, with the bank now going to expire in 1836, sets about removing government deposits from the Bank of the United States because they're unsafe. The bank's going to expire. Congress investigates the bank and discovers actually the deposits are safe. Jackson disagrees, and the Secretary of the Treasury actually refuses to remove the deposits from the bank, so Jackson fires him, replaces him with Roger Taney, the Attorney General, takes out the federal deposits, puts them in state and local banks, and the Senate finds that Jackson has exceeded his constitutional powers and censures him. You'll recall in the Worcester case, the court had been told the Congress can impeach Jackson. They don't, but they do censure him, and it doesn't seem to bother Jackson that much. Okay. So Jackson removes the Indians, makes war on the bank, and neither of these things is going to cause, I don't know if anyone here really upset with the death of the bank. I've had bankers in the class before who do get kind of upset with this. Removal of the Indians? Yeah, that's, I think, a morally repugnant thing. But let me tell you about another thing that happens with Jackson. I'm not sure if this will make you look at him in a different light. What happens is this, back to the old tariff issue. Jackson believed in a low tariff, believed in states' rights, and So, in the when Senator, well, actually, our friend Calhoun, leaves resigns as vice president to become senator from South Carolina again. And there are all kinds of political problems with the in the Jackson administration for Calhoun. And what happens is, so anyway, not to dwell on all of this stuff. Calhoun is senator from South Carolina. South Carolina is still upset with the tariff. This has been an ongoing issue since 1828, and just to give you a break from the discussing the tariff, we put it aside to talk about the Indians and the bank and other things. Now, in South Carolina, at Calhoun's behest, the state calls a convention. The conventions represent the sovereign power of the people of a state, and the people of South Carolina declare that the tariff actually is unconstitutional, that the federal government does not have the power to impose a tariff because, as Calhoun had said, the tariff operates differently in South Carolina than it does in other places. It's actually a detriment to us, a benefit to other parts of the country, and therefore it violates the Constitution, which requires that taxes be uniform, and it advances Calhoun's other interesting theories about the power of the government. And South Carolina says that the tariff being unconstitutional is null in South Carolina, that the state of South Carolina can nullify an unconstitutional federal law. Earlier, they had said that the state can interpose its authority against the federal government. Now they go a step further and say we can nullify a federal law. Where did they get that idea? Who was it you blamed for the interposition a while ago? It's been a while. Jefferson, yeah, Jefferson. In the Kentucky resolutions, Jefferson does use the word nullify. When the South Carolinians say this, Madison says, oh, no, he didn't. Of course he did. And so South Carolina nullifies the tariff, says the tariff won't be collected in South Carolina because it is an unconstitutional thing. Now, as I've mentioned, Jackson is a great supporter of states' rights and a great opponent of the tariff. So what position does he take on nullification and South Carolina's opposition to the tariff, because South Carolina really believes in states' rights? He's against it. Why is he against it?
Because it's presidential power.
Yeah, okay, so Jackson opposes this. Doesn't make as poetic a statement as Webster had, but probably a more effective one. He issues a proclamation to the people of South Carolina, telling them they cannot nullify federal laws. If your leaders could succeed and he tells them, what benefit do you get from the Union? Okay? Are you united at home? Are you free from the apprehension of civil discord with all its fearful consequences? He's reminding them a majority of the people in South Carolina are slaves. Okay? You have this threat hanging over you of civil discord. And then look at our neighboring republics, which every day suffer some new revolution or contend with some new insurrection. Do they excite your envy? The dictates of a high duty oblige me solemnly to announce that you cannot succeed. The laws of the United States must be executed. You said he's against nullification. So what does he do about it? What can he do about it? If he wants the tariff to be collected in South Carolina, what does he have to do?
Arm the tariff collectors.
He has to, arm the tariff collectors. That's, I guess, a possibility. And think about it. This is the so what moment, or the or what. You can't nullify a law. Well, why? Why can't you? Excuse me? You could cut off trade with South Carolina, say, okay, no one can go to South Carolina. I mean, yes? Yeah. Okay. This is ultimately, it's not a question, you're going to resolve by having Webster give a great speech or Jackson issue a proclamation, this is something that is only going to be resolved through force, okay, or through the threat of force, which they know is going to be backed up. Now, it'll be a really bad thing, it might lead to bad consequences. He has to tell them, you're going to hang if you push this, okay? So, I have no discretionary power on this subject. The laws of the United States must be executed. My duty is emphatically pronounced in the Constitution. Those who told you that you might peaceably prevent their execution deceived you. They could not have been deceived themselves. He's talking about Calhoun. Oh yeah, you can peaceably avoid federal law. No. They know that a forcible opposition alone could prevent the execution of the laws, and they know that such opposition must be repelled. Their object is disunion, but be not deceived by names. Disunion by armed force is treason. Are you really ready to incur its guilt? If you are, on the heads of the instigators of the act be the dreadful consequences. On their heads will be the dishonor. On yours will be the punishment. Okay? So if you go along with them, you are going to be punished for treason. And what's the penalty for treason? Death. Exactly. Okay. On your unhappy state will inevitably fall all the evils of the conflict you force upon the government of your country. It cannot exceed to the mad project of disunion of which you would be the first victims. Its first magistrate cannot, if he would, avoid the performance of his duty. This is just a few months after he said he wouldn't enforce the law against the state of Georgia. Now he is going to enforce the law against the state of South Carolina. The consequence must be fearful for you, distressing for your fellow citizens here and to the friends of good government throughout the world. Its enemies have beheld our prosperity with a vexation they could not conceal. It was a standing refutation of their slavish doctrines, and they will point to our discord with the triumph of malignant joy. It is yet in your power to disappoint them. Okay? To say that any state at pleasure may secede from the Union is to say that the United States are not a nation. So Congress passed a force bill giving the president power to use military force to collect the tariff in South Carolina. South Carolina, incidentally, declared the force bill null in South Carolina as well. And it does look like we're going to have the president using military force in South Carolina to collect the tariff, which he doesn't think they should be collecting. But the point is, the Congress and the President govern the country. A state cannot nullify federal laws. And Jackson understands the consequences here. Okay, he might not like the tariff, may believe in states' rights, but what's going to stop some other state from saying, hey, we don't like this particular law? That is a very striking moment in 1832 at the Jefferson-Jackson Day dinner. The Democrats actually had been celebrating Jefferson's birthday, which was in April, and then they combined it with so Jefferson Day dinner. It wasn't yet the Jackson Day dinner. And Jackson and Calhoun are both there, and Calhoun's toast is, do you remember his toast? Okay. Calhoun's toast is, our Union next to our liberty most dear. And Jackson's is, our Union, it must be preserved. And this is one of these questions that is only going to be resolved through force. And in this case, it is the threat of force as South Carolina nullifies the force bill, and then Henry Clay actually engineers a compromise. Congress reduces the tariff rate, South Carolina rescinds the nullification ordinance, and this averts the crisis. But this is not an issue which has gone away. This issue, can a state nullify a federal law? Well, South Carolina still says yes, it can. President Jackson says no, they cannot. We haven't yet come to the point of proving which is right. South Carolina says the Constitution is a compact among sovereign states. Jackson is saying, no, it is not. We have a government of the people of the United States, which Webster has also said. And Clay has also said, Clay is a much more astute politician and not as much interested in political theory. So you have this problem. Are the people of the United States a sovereign entity, or are the people sovereign within each state who have created the United States? And this is a question in 1832 which is not resolved, even though a crisis is averted immediately. I mean, it's still this question lurking beneath the surface, as the Union will continue to be at risk on issues like the tariff, then on issues like slavery, sovereignty, these kinds of questions which are going to continue to trouble us over the rest of the semester. And it's about this time, actually in 1835, when James Madison, actually the last survivor of the Constitutional Convention, wrote a little memorandum which he called Advice to My Country, which he wanted to be published only after he was dead. Incidentally, the same time he thought that the debates of the Constitutional Convention could be published only when the last surviving member died, and it happened to be Madison. And his advice to my country was, in which incidentally I don't believe his country listened to, the advice nearest to my heart and deepest in my convictions is that the union of the states be cherished and perpetuated. Let the open enemy to it be regarded as a Pandora with her box open, and the disguised one as the serpent creeping with his deadly wiles into paradise. So, in 1835, does it seem as though the Union is breaking apart? It's certainly threatened with breaking apart, and Madison, Jackson, Webster certainly see the consequences when the Union does break apart, even if they don't all recognize the issue that is ultimately going to cause it to break apart. So that's it for tonight. When we come back next week, we'll see how we get out of the next mess.